Very well. Please proceed, Mr. Werdeman.
May it please the Court. Mr. Chief Justice, Justices of the Supreme Court, I would like to briefly start today's arguments just describing the important and tremendous significance of Mauna Kea to the Hawaiian people. Mauna Kea is more than a mountain, it is the embodiment of the Hawaiian people. Mauna Kea Kuahiwi, Kuhao Ka Malie. Mauna Kea is an astonishing mountain that stands in the calm. Mary Kavena Pukui, 1983. It's an old saying that expresses the sentiment among the Hawaiian people that Mauna Kea is a source of awe and inspiration. This is, as the Court is well aware, one of the most significant and important cultural sites in Hawaii. It is the source of the genealogical story of the Hawaiian people, of Papa and Wakea, the creation story. This is the source, this is the piko, this is the beginning for Hawaiian people, for Hawaiian society, for Hawaiian culture. This is the source. And that's, in that light, I'd like to proceed with today's arguments. Unfortunately, given that tremendous significance and cultural aspects with respect to Mauna Kea, Mauna Kea has really become an absolute mess. It's there's been significant adverse impact that's been found. We have what is essentially an industrial center up on top of the conservation district on the summit of Mauna Kea. And this has been going on for many years. It has been the source of scathing audits by the state auditors. I would submit to the Court it is a situation that is out of hand. The governor has, as the Court is probably aware, recently spoke about the need for better management on Mauna Kea. He has come out with a variety of points that he needs to be addressed, including needing to be better stewards on the mountain. And in all of this, if I may, just briefly overview the process that this project has gone through. And that has, we started off with a comprehensive management plan that excluded coverage of Mauna Kea. We then had and that was in 2009. We then had a application for the Conservation District use permit by the University of Hawaii, who interestingly has been carrying the ball for the 30-meter telescope nonprofit corporation throughout these proceedings for whatever reason. And along with that application that was submitted in September of 2010, there was what was called a management plan, not a comprehensive management plan, that was site-specific to the TMT project, which is on the north ridge of the Mauna Kea, right next to the summit area that's already been overdeveloped with multiple telescopes dating back to the 1960s. And what happened is, subsequent to that application, there was a hearing in which my clients had stated that the Board of Land and Natural Resource can't go forward and grant this application without first holding contested case hearings. And despite those pleads. The Board of Land and Natural Resources granted the application, and then in that same hearing that followed said, well, we're now going to give you your chance for a contested case hearing, after they already ruled, albeit what they called a conditional approval, which was essentially nothing more than saying we're going to stay construction until we hold these contested case hearings. Why would the Board of Land and Natural Resources make a conditional finding to begin with? There's nothing in our rules that allow for it. There's completely arbitrary and capricious. It's really setting a terrible standard for administrative proceedings throughout by setting this trend, it seems, to grant these. We're gonna give you a permit, but we're gonna give the people that come in and ask for contested case hearing their permit. But don't worry about it. We're gonna rest assured we're giving your permit, and we're giving this conditional granting of it.
Mr. Werdeman, is there anything that prohibited that process from being done in that way? And are there, I believe there's a rule that allows the board to adopt processes that best serve the purpose of the proceedings as long as they're not prohibited. And so my question is there some way in which it's prohibited, and does that rule have any bearing at all in whether this was appropriate or not in your view?
Certainly, due process, a meaningful time in a meaningful manner. There's certainly and the right to be heard. The right to be heard before a decision is made, before a quote-unquote conditional decision is to be made. That's what's critical here. There was no reason for the board, to grant this conditional permit. It was on the same agenda.
Excuse me. Is
Yes.
it a conditional permit? The way I read it, it was a permit. It was issued, and it stayed one process, the construction. But the
Yes.
permit was issued. It's not a conditional permit. It's a permit which has a condition, but that doesn't make it conditional.
Well, that's what it was called, Your Honor, by the board,
But
certainly.
does the permit say it's conditional? Does it say anything in this that says this is a conditional permit?
And they stayed construction, and certainly they did predispose and predetermine the whole issues before the rights, duties, and privileges of the petitioners were determined. And that's wrong. That's repugnant to due process. That's repugnant to the whole idea of the right to be heard in a meaningful time, at a meaningful time, and in a meaningful manner.
Mr. Werdeman, I'm sorry to interrupt you, but I did want to ask you about that point. You were talking about the right to due process, the right to be heard in a meaningful manner. Can you speak a bit about what that means with respect to a contested case hearing? In other words, what sort of rights were you anticipating would apply that would be of significance to your clients in the contested case context? And in that regard, I'm sure you're aware that the position that is taken by the university and the board is that actually you did get a contested case hearing. So can you speak to why, from the point of view of your clients, the due process that they're seeking would suggest that they should be entitled to another contested case hearing?
I would submit, Your Honor, that the whole idea of due process is to be heard before decisions are made, and to determine the rights. The rights, duties, and privileges were already determined by the Board of Land and Natural Resources even before the contested case hearings were held. The hearings officer was certainly aware of that. There's certainly at a minimum a appearance of improprieties in all of that, and I'm just respectfully submitting that the court set this whole process straight, that if there's a contested case hearing that's going to be held, if the parties have a right to that contested case hearing, that that contested case hearing be held before any decisions are made by the board. Because the whole purpose of the contested case hearing, again, is to determine first the rights, duties, and privileges of the parties.
Mr. Werderman, how do you respond to the appellee's proposition that the reason the permit was set forth beforehand was to add more of a form to the arguments? In other words, to give you an opportunity to understand what their thoughts were so that you could better your arguments at the contested case hearing?
I submit that that argument is unfounded. Again, that my clients knew what their cultural practices were. They knew what their arguments were with respect to the significance of the cultural and natural and archaeological sites up on the Mauna. That is, Justice Wilson, again, in answer to your question, those are the things that we're being deprived of in this predetermination of the issues in this case by the board. I think the subsequent, I'm sorry.
No, the thing I was going to ask, Mr. Werderman, is the process improved or at least a legitimate interest served by having the permit and the conditions of the permit there for the parties to then be able to respond to at the contested case hearing? There are numerous conditions in the permit. Some of them are very specific. And would that give the parties the opportunity to criticize, conditions 17, 18, 23, 24, inadequate for the following reasons, they need to be amended, as opposed to just generally responding to the notion that this telescope was going to be built, have actually the permit conditions there to be able to respond to in detail at the contested case hearing? Is that a legitimate interest that you think it was served by this process, or would you disagree with that proposition?
I would certainly disagree with that. The application was there for everyone's review. The board didn't have and shouldn't have made it a predetermination of the issue on it. So that would certainly answer the questions presented by you, Mr. Chief Justice, that that this should have gone forward with the contested case hearing, that the board obviously was well aware of that they were going to grant at that hearing. Again, the issues were predetermined. And I think
is there anything in the rules that say that permits shall be approved before the contested hearing so that the issues can be better understood by the parties?
Well, that's certainly.
Is there anything in the rules like that?
That's certainly part of my objections to all of this process.
And isn't there a procedure for, you want to support the issues? 13-129 says the party requesting it shall state explicitly the issues and that the disagreement the requester has with the application, not with the approval, with the application. And 91.9 talks about the requirement of setting forth the issues. There's nothing said, and that's done through a particular notice. That's not done through approving an application before the hearing. Is it? Is there any procedure in the rules that allow this?
No, Your Honor, I would submit it, and even if there was, it would be repugnant to the due process requirements.
If we were to agree with you, what would your remedy be? Wouldn't it be going back to a board to rehear the same matter again?
I would submit that that is the only remedy to address the due process violation. We have a new board, certainly.
This is a completely new board than the one who heard it before?
As far as I'm aware, I may be mistaken, but I believe that most of the board members stepped down with the financial disclosure requirements previously that were implemented by the legislature, and a whole new board was appointed. So I think there it is a brand new board. There's an opportunity to have a new hearings officer convene as well, and to vet out the issues the way it should have been done in the first place.
Mr. Werdeman, you're focusing understandably on the opportunity for a contested case hearing under 13-129, but I did want to ask you to speak as to your position regarding the discussion that was in the Keela Keela case. I think that Justice Acoba focused on it to some extent as to whether your clients have a constitutional right, a sort of due process right arising from Article 12, Section 7, as well as Article 11 of the Hawaii Constitution. What is your position as to whether the right to a contested case is grounded as well in the Constitution?
I certainly agree with that, and I think it was really indisputed in this case that there was a right to contest a case hearing. It wasn't objected to in any way. The contested case hearing did proceed. I think all of those rights are certainly at issue here, Your Honor. With respect to the elements of Hawaii Administrative Rules 13.5-30, subparagraph C, these are the 8 administrative standards that are codified in the rules that must be met in order for a conservation district use permit to be granted. And again, it's undisputed that, and it was set forth in the conclusions of Law 92, that the cumulative effects of astronomical development and other uses in the summit area of Mauna Kea have previously resulted in impacts that are significant and adverse. That's already established. What the appellees seem to argue, and what the hearings officer and the board subsequently found, was that the Morimoto case, that you can consider mitigation, but the mitigation that was proposed by the university and set forth by the board and found by the board was not the kind of mitigation that was present in Morimoto. It didn't address the issues of how do we deal with the impact of building a highway through a palila bird habitat. And in that case, what they did was, that mitigation was they set forth 10,000 acres of reforestation to better allow for the palila bird survival. What they did in this case was they came up with, because we would submit there's nothing really that could be mitigated because it's already overdeveloped up on Mauna Kea. But what University of Hawaii did as far as so-called mitigation is that they came up with community benefit packages, workforce, projects, some scholarship funds for the community, nothing that dealt with the impact itself in the conservation district. And that's...
Could I interrupt you? If I could ask you about this issue of impact that you've just addressed and the idea of a mitigation that would address the impact, so to speak. You've mentioned that there's a determination that's an official determination at this point that there really isn't a substantial adverse impact, correct?
Yeah.
That's at this point.
Yeah.
That idea that there's no substantial adverse impact seems to be based on this approach which you've described as sort of incremental degradation, that the mountain, albeit a significant cultural resource at some point, has been degraded significantly to the point that now it's, with the addition of the telescope, not true to say that there is a substantial adverse impact on the culture, correct? That's the position that's being taken. So if that is the case, Mr. Werdeman, I'm interested in your explanation for how is it that it appears from the testimony of Mr. White and Mr. Hayes, the individuals that put together the conservation use permit, as well as the EIS, the cultural section, their view is that there's been this incremental degradation because of, and there's a list in the cultural section of 21 different actions that have taken place over time, including building telescopes and roads, that according to the testimony of Mr. Hayes anyways, means that the mountain has now been degraded to the point where the addition of a telescope isn't significant. So I wanted to ask you if you could speak to that analysis. Is that the core of the idea that the mountain has been incrementally degraded? The fact that, according to the analysis of Parsons Brinkerhoff in the EIS, that means that there is a substantial adverse impact that is so great that the addition of a telescope won't make any difference?
Certainly, I mean, what the university is proposing or is arguing in all of this is really that it's already a mess up there. What's a little bit more of a mess? I mean,
But how do they come to the specific legal definition that the mess equals such a significant degradation that a telescope doesn't really make a difference at this point?
Well, then it needs, as the governor has pointed out, remedial measures need to be taken and started today and years ago.
And
We can't incrementally, I'm sorry.
Oh, no, finish. Please finish. I'm sorry.
Incrementally continue to build and build and build up there just because there's a finding of substantial adverse impact. This is a conservation district. This is not an industrial district. This is a conservation district where preserving natural resources is significant, and that's what the legislature has found. And what the university and what the state administration needs to do is start addressing the problem, not continue to add to it.
Mr. Werdeman, in that regard, I noted that the witness who testified for the university regarding, who's the author of the application, Mr. Perry White, testified, was asked this question, how can you say that it's not substantial? And one of the things that he pointed to was that there was an expectation some telescopes would be decommissioned and that there would be a rolling back, and that when one considers that over time some of the telescopes would be decommissioned, we felt that it was on balance not a bad thing. Now my question is there anything in the permit that in any way restricts the number of telescopes that can be built on Mauna Kea in the future, or that contains commitments regarding decommissioning of current telescopes?
Well, there's discussion in the finding and an application of putting together a decommissioning plan for TMT. There's really no concrete, legally binding obligations I would submit right now that would require the university as the lessee of the Mauna Kea Science Reserve to be required to do those things that you're talking about.
And would those be, in your view, appropriate conditions for a permit? And is the absence of those requirements one of the factors that, in your view, makes this permit improperly granted, or is that not the kind of mitigation that you're seeking in this case?
Well, I think it's something that needs to be considered in the balance during a process that's not predetermined. It's certainly, especially when there's significant and adverse impact already up there. The analysis and the management plans that should have been presented and proposed should have addressed those issues. They should have said, you know, we have this situation up there. How do we address it before we start allowing any more telescope development? and continue this significant and adverse impact in this conservation district. That wasn't done here. That certainly should have at least been considered and discussed in the process. I wouldn't agree that it would necessarily turn out in the end that would allow for the telescope to be built at that point, but it's certainly something that should have been considered.
In your view, in the position of the appellants, what should be done, or are there any combination of conditions that would allow the construction of this telescope, or is it because of the nature of what's already on the mountain, it's precluded as a matter of law in your view?
Well, certainly as it stands today, the telescope should not be built or should not be allowed to be built whatsoever. I think it's a very long and involved process to really sit down and analyze at what point this significant and adverse impact becomes less than significant and adverse, and whether the telescope at that point can even be built, again, taking into consideration the cultural, archaeological, natural resources in this conservation district at Mauna Kea.
So your view would be if there were limits on telescope construction and or requirements regarding decommissioning, that's something that should be in the discussion, but you cannot say that that alone would be enough to make it the impact to the point where you would be able to agree that the test had been met, that there was no substantial.
I think it certainly should be in the discussion with respect to taking it less than significant and adverse up on Mauna Kea. That needs to be done before any further development can even be considered. And so that is my.
Can you clarify something for me? Now, there was a comprehensive management plan which addressed a broader area of the mountain, and then a TMT-specific management plan. Did either of those plans contain binding requirements related to future development of the mountain in terms of additional telescopes or decommissioning? Well,
it's certainly, the so-called comprehensive management plan, specifically, and it states in section 2.3, that's at page 21, Record on Appeal 42, that it was not considering the 30-meter telescope in that so-called comprehensive management plan. And so what happened is, subsequent to that, again in 2010, a site-specific plan was submitted, but at that time it wasn't even allowed for under the rules. What the rules allowed for was, or required, was that this comprehensive management plan be put together, and it wasn't done. What interestingly happened, and it's really a commentary on this whole process, is that after it was submitted with along with the Conservation District Use application, and then the hearing in February of 2011 was held. Later that year, the board changes the rules. And they say, oh, you no longer need a comprehensive management plan as long as you have a site-specific management plan. And unless the board finds that a comprehensive management plan is necessary. That's essentially what happened. So this project is being railroaded through. They're predetermining the issues on the granting of the application. They changed the rules to allow it to go forward because obviously the management plan that was submitted with the application was insufficient under the rules.
In your view, the comprehensive management plan would not have satisfied the rules that existed at the time it was submitted because it did not address the TMT project? Is that the position of the appellants?
Yes, and it should have also addressed the entire impact on the conservation district on Mauna Kea as well, and not just focused on the Mauna Kea Science Reserve.
So which version of the rules should have been applied by the hearing officer and then ultimately the board when the board ruled in 2013? The 2009 version of the rules or the 2011? Because under the 2011 version, there was not a requirement, there was no finding that a comprehensive management plan was required.
Right. I certainly think the pre-2011 issues, I mean, if there's going to be any meaningful review of the conservation district at Mauna Kea, especially with a significant and adverse impact, I mean, let's have a comprehensive management plan that does what it's supposed to do. Because otherwise, we just have all this paper with a bunch of empty promises. And these management plans really don't mean a thing. There's no, again, concrete requirements on decommissioning that are of any note. And, you know, it really, it's really appalling that the rules were changed the way they were just to get this project moving through and to let them proceed with a management plan that didn't really do what it was supposed to do.
Mr. Werdeman, there are other administrative procedures throughout the state, in both the city and the state level, whereby a hearings officer can initially hear a matter and then also sit on the panel that reviews it. How is, and we have said that that's okay, absent actual prejudice or actual bias. How is that different in this case?
I'm sorry,
With a hearings officer who makes a preliminary, who makes a ruling and then sits on the panel that hears it on appeal?
The hearings officer wasn't.
I'm referring to like Cecil v. City and County.
But in this case, the hearings officer wasn't on the board. I'm not sure if I understand.
Well, I guess what I'm
your
saying is,
question.
although there's a preliminary decision, then the appeal officer isn't this the same board that did the preliminary? That was a hearings officer.
Yes, there was
Preliminary
a board that convened. They made a determination on the conservation district permit,
Right.
use permit. It was then referred to a hearings officer who conducted the contested case hearing, and then subsequently the board adopted the findings and conclusions of the hearings officer.
Was it the same board that heard the preliminary, what they called the preliminary permit, as the one that heard the contested case hearing?
I'm not sure if all of the board members are the same. On the first one that were present at the time of the confirmation, for lack of a better term. But it was certainly the process that was followed.
Well, I guess the parallel is, why would it be okay for a hearings officer to make an initial determination and then sit on the board, and it not be okay for a board to make the initial determination and then reconsider it also? Well,
I think what's it's more than a predetermination. It's more than what's being presented by Your Honor. This is an approval of the permit that allows them to go forward with the construction on the telescope before we even got started.
But it didn't, in this case, it didn't allow that, though, right? I thought that what was approved specifically precluded construction from beginning.
Right. I mean, that was the only so-called condition that was placed, that you have to wait until the contested case hearings are held before you can move forward, and that's when this subsequent confirmation was held.
The federal courts have cases, I think there's a case called Withrow that we cited in some of our cases that talks about a medical board that had made a determination there was enough evidence to proceed against a physician with regard to his license, and then that same board adjudicated the case, and that was thought not to be violated of due process, even though one group or the board had made a preliminary determination and then came back and made a final determination. That and other cases cited by the university, they argue that those cases have found that's not a violation of due process. What's your response to that argument?
It certainly is. This isn't a preliminary kind of probable cause determination. This is a granting of the application right from the get-go. I think the fact that they stayed construction, the argument that the appellees are making is that that's not a final decision order for, really for purposes, and this was the issue in Kila Kila, or a primary issue in Kila Kila, was that whether it was an appealable ruling at that point. It didn't change the stakes as far as predetermining the issues. The stay on the construction, that didn't change in any way their predetermination and predisposition of the issues. And finally, I guess I'm out of time. I'll save the rest for rebuttal.
If you want. Yeah. Okay, we'll hear from the appellees, and then we'll hear back from you in rebuttal, Mr. Werdeman. Very well.